чтобы окончательно закрыть дело о суде, который отложили, и который не проигран. Слушаем судебное заседание, взятое из открытых источников. У нас остался только один вопрос. Люся, куда ты дела $100 000, которые пыталась не отдать банку, а?
Good morning. Are you here for 2020 CA 2614? Yes. I'm sorry, hold on. Let me read that back to me, I'm sorry. 2020 CA 2614? Yes. Okay. My name is Ludmila Hensley. I'm sorry? Let me just get this document. Okay. It's Maria Lindana on behalf of Wells Fargo. Yes, it's 2020 CA 002614. Okay, is there anyone else on the phone, Miss Lindana? No, I don't think so. No? Okay. One moment, and I'll put the judge on. Thank you.
Good morning, this is Judge Kess. Who's on the phone?
Good morning, Your Honor. Lindana. On behalf of Ludmila Hensley.
Okay, we are getting a reverberation on your phone. I'm not sure why.
On my phone, Your Honor?
Yeah, now you're okay. It was coming a moment ago. Could not hear you for just a minute. Tell me your name, please.
Maria Lindano, on behalf of Wells Fargo.
Okay. Can you spell your last name for me?
Yes, sir. It's Londono.
Just like it sounds.
Yes, exactly.
Thank you. Okay, which usually doesn't help me. Have you heard from Miss Hensley at all?
She's on the line, Your Honor.
Oh, she is. Miss Hensley, good morning.
Good morning, Your Honor. How are you?
Good. Tell me how you pronounce your first name. I've been killing myself trying to say it.
Yes, Ludmila. Lyud. You just want to hear my name, Ludmila.
It's Ludmila? Okay.
Yes.
That is a very unusual name. I had a lot of trouble with it.
A Croatian name, yes.
Okay. Miss Lindana, do we have a court reporter in this case or not?
We do not. Not today, Your Honor.
All right. This is your motion to dismiss, or in the alternative, motion for summary judgment. I have had a chance to review your motion. I've had a chance also to review Ms. Hensley's response in this matter. The motion for summary judgment I think we can deal with pretty quickly because it has not been 20 days since that motion has been filed, so the requirements of the rules are at least 20 days notice.
So that would be on the 26th, so I'm sorry, go on.
That's okay, so I could not do anything with that at this point anyway. But the motion to dismiss we can, so let me let you go forward, ma'am.
Yes, sir. Okay, so in her complaint, plaintiff is asserting a claim to quiet title based on her deceased husband being the sole borrower on a line of credit executed in favor of Wells Fargo. Plaintiff alleges that her late husband executed and delivered a mortgage for Wells Fargo in connection with this line of credit without her knowledge or assent. Plaintiff also alleges that her late husband fraudulently included himself on a quitclaim deed in order to convey the property at issue to himself and plaintiff jointly. Plaintiff is essentially seeking to remove Wells Fargo's valid mortgage as a lien on the property. Your Honor, the basis of Wells Fargo's motion to dismiss is simple. The mortgage is a valid lien on the property, and it's not a cloud on the title as a matter of law. Plaintiff references the mortgage at issue in her complaint, and the mortgage is obviously central to her quiet title claim, but she failed to attach it. Since she incorporated the mortgage by reference, the court is entitled to review the mortgage in evaluating whether the complaint states a valid claim for quiet title. We actually attached the mortgage as an exhibit to our motion to dismiss. It's Exhibit A. So as I stated earlier, the crux of plaintiff's complaint is that her late husband was the sole borrower on the note. And, Your Honor, that may be true, but it's not relevant because the mortgage at issue is signed by both plaintiff and her late husband jointly. That's clear on the face of the mortgage. It's well established that a valid and enforceable mortgage does not constitute a cloud on title. That's from 210-3 SFR Venture LLC versus Garcia. That's a 4th CCA case. And an action for quiet title based on a valid mortgage, such as the one that we have here, is subject to dismissal, and that's from U.S. Bank National Association v. Bartram. That's a 5th CCA case. So, contrary to plaintiff's allegation that she was unaware of the mortgage's existence. Plaintiff is identified as a mortgagor in the instrument. She signed the instrument, and the notary acknowledgement on the mortgage verifies her signature on the mortgage. In sum, Your Honor, the mortgage is a validly executed and enforceable lien on the property. It has not been repaid, and therefore it's not a cloud on the title. As such, plaintiff has failed to state a claim for quiet title, and the complaint should be dismissed.
Thank you. Ms. Helmsley, this is a legal proceeding in which the bank has asked me to dismiss the complaint, saying there is a legal basis that this complaint cannot go forward. You heard what the argument was. You had a chance to read their motion that was sent. Is there anything you wish to tell me, ma'am?
Yes, I would like to tell you, yes. I hope you have the letter about Fargo sent to my ex-husband.
I have everything that you sent me, ma'am.
Yes, and this letter said, my ex-husband was simple borrower, and not jointly with his ex-wife with me. And I think, just give me a minute, I just tried it. Can I just read it, everything, please? It's small. Just give me a minute.
I'm sorry, I missed the last thing you said, ma'am. Ma'am?
Just give me a minute. Okay, ownership has nothing to do with you as contract law. This is not the establish the ownership of my real property on my name. And they, Wells Fargo, agreed. I have nothing to do with this Wells Fargo loan, equity loan.
Okay. Anything else you wish to tell me, ma'am?
Yes, I got, I take it everything, and I wanted to read it, everything for you, but it's my source, hearing, because I could not afford the attorney, and I tried to do it myself, represent myself. I'm so sorry, and my English is not so good, it's because I'm a good boy.
I can understand you, okay? Thank you.
Yeah. What I want you to read, okay. When I found my husband altered my deed against his name, send writing on the notarized deed, which is absolutely void and wholly ineffectual to pass title, because any alteration of the deed is erasure or submission of the name of the grantee is a material alternation and forgery due to reference man versus man, Florida District Court of Appeals 1996. After I got the defendant motion to dismiss, I started to search all my ex-husband's documents and found the letter from Wells Fargo mailed to my ex-husband David as a resolution to his inquiry about his loan. They determined my husband got this loan as a simple borrower in his name only. If you see an agreement, there is just his name only. And to tell you more, Your Honor, I came to America to US the year before he got this equity loan, and I did not speak English. I remember something, but I said, I'm a lawyer in my country, in Russia, and I said to him, I would never sign anything. He said, no, don't worry, you will sign like a witness. And I forgot about it. I forgot everything because I did not know what was going on. After he died, I realized something is going on. This is why I filed a complaint, and I asked you, and I'm asking you to dismiss defendant's motion, remove the cloud of my deed, as well as establish the ownership of my real property only on my name only, please.
Do we have any response?
Well, Your Honor, I think plaintiff's assertion that her husband fraudulently altered the quitclaim deed to include himself as the grantee jointly with plaintiff is immaterial to the question of whether the mortgage is a cloud on the title, whether she derived title to the property solely in her own name or jointly with her husband. The fact remains that plaintiff herself granted and assented to the mortgage lien on the property. So what solely in his name?
This is a equity. Wait a minute, ma'am. Ms. Londano, this is a equity lien. Is that correct?
Yes, sir.
Okay. Yes, ma'am. Did you have something else?
Yes,
Ms. Hensley?
yes. Wells Fargo did not provide this letter to the representative attorney. This is why it happened. Because Wells Fargo returned just his name, and he's just single borrower. You can see this on the Wells Fargo letter. Wells Fargo contradicts him. I'm done.
Okay, thank you, ma'am. I have reviewed the documents you sent me. I've listened to what you said. I've reviewed the court file. This is a complaint to quiet title. This is not a mortgage foreclosure or anything of that nature.
Right.
Having reviewed the matter, it appears that the defendant is entitled to have this matter dismissed. It is not going to be a dismissal with prejudice. This is the first time this has come up. Will you allow you an opportunity to amend? I'll give you 30 days to amend because of what's going on with this COVID-19. But I'm going to go ahead and grant the motion to dismiss with 30 days to amend if you believe you can correct deficiencies in there. I'm not sure you can, but I want to give you the opportunity to do that. Ms. Hondano, would you do an order for me, please?
Yes, sir. Should I send it over? Yes, sir. I'll send it over to your judicial assistant.
Yes, make sure you run it past Ms. Hensley first, if you would, please.
Of course.
All right.
Thank you, Your Honor.
Thank you. Thank you, Ms. Hensley.
Thank you so much. Have a good day.
You too.
Take care.
The conference will end in 2 minutes.